Hello and welcome to Mackenzie Friend. Today we're going to look at changing a child's name with respect to the Family Law Act. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I do not practice nor have sought admission. Therefore, any information cannot be relied upon. Any questions should be directed towards an accredited family law specialist. So firstly, let's look at what is meant by parental responsibility under Section 4 of the Family Law Act. Under D, a child's name is detailed as an element of parental responsibility. Under 61C, each parent has parental responsibility subject to court orders. What this means is that common law and under the Family Law Act, unless the court orders otherwise, parents have parental responsibility. And this does not change if parents are separated or either of them being married or remarried. Now, Section 61B is the meaning of parental responsibility. In this part, parental responsibility in relation to a child means all duties, powers, responsibilities, and authority which by law parents have in relation to a child. The Section 61DA, there is a presumption of equal shared parental responsibility when making a parenting order. A parenting order confers parental responsibility for a child on a person, but only to the extent to which the order confers on the person duties, powers, responsibilities, and authority in relation to the child. A parenting order in relation to a child does not take away or diminish any aspect of parental responsibility of any person for the child except to the extent expressly provided for in the order or necessary to give effect to the order. Let's look at some case law. Flanagan and Hancock, 2001. In this matter, the full court held that the power to change a child's name is clearly an aspect of parental responsibility as defined by 61D of the Family Law Act. In Chapman and Palmer in 1978, there were 6 factors that were considered. Firstly, the welfare of the child is a paramount consideration, which is also Section 61CA of the Family Law Act. The short and long-term effects of any child in the child's surname. Any embarrassment likely to be suffered by the child if its name is different from that of a parent with custody or parent control. Any confusion of identity which may arise for the child if his or her name is changed or not changed. The effect which any change in surname may have on the relationship between the child and the parent whose name the child bore during the marriage. The effect of frequent or random changes of name. Also in Beach and Stemler in 1979, some additional factors were considered. The advantage both in the short and in the long term which accrue to the children if their name remains as is now. The contact that the husband had and is likely to have in the future with the children. The degree of identification that child now have with their father. The desire of the father that the original name be restored. The views of the child if of sufficient maturity. It is generally considered accepted practice in Australia that a child, particularly a male, adopts a father's surname. It must be considered that the same issue arises if the mother seeks orders for the maiden name for the child but intends to change the surname upon any marriage in the future, whether the mother has any other children with a different father and surname. Cultural issues were raised in Potrino and Jackson, where Lunsig J found that the child's Italian family had a great deal to offer him. Verona held that the child should continue to bear that surname and be able to enjoy the benefits of his association with that family. The propagation of family name and any other offspring of the father's siblings. Contraventions, undertakings, or requests to desist of the non-birth registered name. Also, the use of the child's name on trophies and prizes. Just a quick look at hyphenated surnames. In DL and W in 2004, the hyphenated surname might create difficulty in spelling or become excessively long and is inconsistent with everyday use. In Mahoney and Mackenzie in 1993, the child had been registered in the father's surname at birth and the mother reverted to the use of her family name after parting separators. The father found out that the child was attending preschool under the mother's surname and sought orders to ensure that the child was known by his surname. In this case, 1J attached no significance to the fact that the child's surname had been registered as the father's surname at birth. So, when we talk about making a case, it is likely insufficient to argue that the parents must agree in the presence of equal shared responsibility. The best arguments would draw back to the child's best interest based upon the relevant considerations, as previously mentioned. Family law is highly discretionary, and the court may have regard for the history of litigation, previous negative findings against the parent, the attitude, demeanour and presentation of the parents at hearing. Conclusion. Changing the name of a child is an element of parental responsibility. The outcome may turn on individual facts and circumstances, and there is a high level of judicial discretion in family law. I hope this helps.